And so then the title for this one is, does copyright apply to that? And most of the time we're going to say yes. So thank you for coming to my presentation. And now we'll go a little bit further than that. But most of the time you just want to assume copyright does apply, and we're going to look at why. Okay, so this workshop is part of a series to help you advance your research skills and support your scholarly activities. And so we've got 4 objectives for this little workshop. We're going to define copyright and look at what it means. We're going to learn the 4 principles of fair use. We're going to define the public domain, and we're just going to have a definition for the Teach Act, because folks get the Teach Act confused pretty frequently. Okay, now I have a mandatory disclaimer here. I am not a lawyer. I did take the LSAT, but I did not go to law school. So I cannot practice law or give legal advice. So if for any questions, my answer is probably going to be, well, it depends. So don't get frustrated with me. And we do have a copyright guide here at ACOM. I had to make this guide as part of the Special Library's Copyright Management Certificate. So this is a really good copyright guideline, if I do say so myself. So if anybody wants to review it, I send out the link for that. All right, so this is the United States Constitution, Article 1, Section 8. Congress shall have power to promote progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So that's the initial blurb. Okay, now I wanted to use an image for this workshop, these slides, but on researching that image, I realized I couldn't. Okay, so we have Daumier here, the pleading lawyer. It's a really cool painting. And this painting is at the Hammer Museum in Los Angeles. Now, here's the thing. Daumier died in 1879. So his painting, he's been dead for over 100 years. So his painting is in the public domain. However, upon looking at the museum website, they have this little blurb right here. And you will notice it says the Hammer retains all rights, including copyright, in the materials. And they say that everything is collectively known as the materials. Therefore, I cannot show you a picture of that painting. Even though it's just a digital representation of the painting, I can't show it because they have the permissions for it, right? But I'll link to it so you can go see it yourself. And it is a pretty cool painting. Now, the first thing we want to do is we want to define intellectual property. And intellectual property, and this is one of the best definitions in the whole world, it refers to the creations of the mind, such as inventions, literary and artistic works, designs, symbols. Like you remember when Prince changed his name to a symbol, right? Names and images used in commerce. And the whole of intellectual property is protected by patents, copyright, and trademarks. Okay, and this enables people to earn recognition and or financial benefit for the things that they create or invent. And so what we want to do with copyright and other laws like this is we want to provide balance. You got to have a balance between the interest of the people that create the stuff and then the wider public interest. Okay, so it wants to, IP systems aim to foster an environment where creativity and innovation flourishes. All right, so lots of times people get these confused, but a trademark, we want to make sure we know what each one of these are. A trademark protects any words, names, symbols, devices used in commerce to identify and distinguish a particular source of goods or services from another. So this is where you get into the Nike swoosh, you get into the Mickey Mouse ears and all that kind of stuff. A patent relates to an invention. So you invent something, you have a patent for it, and no one else gets to make another invention that does the thing until your patent is up. So it gives you, time to earn the financial benefit and the reputation for having invented this wonderful thing. A registered design is the appearance of a product or parts of the product. Like I like Keens for shoes, and they have that little rubber sole piece that comes up over the toe. So that's an appearance thing for Keens. So that could be, I don't know that they registered that design, but they could, right? Now, copyright, what we're focused on today, is a form of protection provided to authors of original works of authorship. This includes literary, dramatic, musical, artistic, and certain other intellectual works that are both published and unpublished. So if you go to the copyright law of the United States website, you get this little blurb first. And I show you this because you can download the whole law. You can also purchase it in print. But you see here, they're always making adjustments for it. So we have a 2016 adjustment, 2018, and we even have something here for coronavirus aid relief. This actually has to do with renewing copyright. It's giving people extra time. Like you have extra time to file your taxes because of coronavirus, you have extra time to reapply or extend your copyright. So that was pretty interesting to me. But it's always under review. It's a fluid thing. It changes and adjusts as the environment changes. Now here's the whole thing. You can read the whole thing if you want to. It's over 370 pages. It's really good reading if you can't sleep, but it is there in its entirety for you to look at. Now remember, unless you're a lawyer, you can't really interpret this for other people. So don't practice law, but you can read it if you want to. Now here's a little blurb that we're going to focus on for this workshop. So copyright gives the creator, author, artist, whatever, exclusive rights, right? And these exclusive rights focus on these 6 little pieces right here. So if you have a copyrighted work, it is on you. You have the right to reproduce it, right? You have the right to prepare derivative works. So this is where you get, Star Wars episode 4, 5, 6, episode 1, 2, 3, and then episode 7, 8, 9, right? Derivative works. You have the rights to distribute it, make copies, that sort of stuff. You have the right to perform the work publicly if you've written a play or a song or something like that, or compose something, that it's your exclusive right to perform it. In the case of literary, musical, dramatic, choreographic, pantomimes, anything like that, sculptures, it's your exclusive right to display it, all right? In the case of a little special note here for sound recordings, to perform the copyright work publicly in digital format, which, that's pretty cool. That's one of the things that was added, now we have digital. So those are the 6 things that are the exclusive rights of the copyright holder. Okay. Now, we talked about the painting at the Hammer Museum. So I want to show y'all this. This is a photo. This is my good friend here, Jarvis. He's a super duper dog, and his mom took this picture. She owns the copyright for Jarvis right there, for this image. And I told her, I said, I love that image. May I sketch it? And she said, absolutely. So I did a sketch of Jarvis there. Now here, she owns the copyright to his photo, but now I own the copyright to my sketch, which is pretty interesting. When you get into visual things and pieces of art and images, the copyright gets even murkier of who owns what and how much of it you can display. So we're going to look at that differently. But when you look, or in a minute, but when you look at this picture, this photo of Jarvis, she completely owns that photo. And I completely own my image there. Now, here's the thing, and this is where we get wrecked up. You do not have to have that little C, right? If you don't see that little C, it doesn't mean that it's not under copyright. Copyright is automatic and immediate upon the creation of original works. Once they're in that fixed, tangible medium, copyright's there. So we say that again. Copyright is automatic and immediate. So this is a heartbreaking when I did a class, and I won't say where, it was not here, but I did a copyright class at a big university, and one of the professors there was internationally known, and she had done a lot of research, and we asked, a question, and she said, oh, I didn't have to worry about copyright because it was on Google. And so we had to explain how that wasn't correct in a very, very nice way, and make sure that we got her situated so that she wasn't breaking the law. So even if it's on Google, right, and there's no little copyright C, still, you should assume copyright applies and do your due diligence to clear that copyright so you don't get sued and your institution does not get sued. And if you think it's not serious, we've got case law. Disney is one of the ones that really protects their stuff, right? But also we have the case of Georgia State and their course packs. So you can get sued. So you want to be careful. And plus you don't morally and just ethically, you don't want to take other people's stuff. And even if you cite it, that's still not good enough. Attribution is not permission. Okay, so what's in the scope of copyright? Well, literary works, sure. Musical, dramatic, graphic, motion pictures, of course, sound recordings. You don't necessarily think of architectural works, but that can be under copyright. Video, audio, graphics. You don't think about email very much, but email falls under copyright. And websites. A website falls under copyright. And then embedded things on a website. And remember, this includes things on Google and from library resources. Now, when you get into library resources, generally when you have that license is going to tell you how you can use that particular resource. Okay, now there are things out of scope. So what are the kind of things out of scope of copyright? Well, a theory, an idea. Abraham Lincoln's birthday being February 12th. You can say that without attributing that to his birth certificate, if he had one. Data, titles, slogans, names, works from the US government, but I've got a little star right there. Generally, government documents are out of copyright. You can use them as you will. However, sometimes the government contracts things, images, research. It could be the whole piece, and it's possible that the creator or the photographer retains the copyright and is just letting the government use it. So you have to watch for stuff like that. A list of ingredients or procedures, and things like the phone book. Those things are kind of out of scope for copyright. Now, some things are in the public domain, and we can get confused with this, right? These refer to things not protected by copyright, trademark, or patent. So the public now owns the works. And works in the public domain can be used without getting permission. So if we go back to the Hammer Museum and I take my own picture of the lawyer, I can use my picture of that painting, but I can't use their digital copy off their website for my slides. Okay. But even if something's in the public domain, you should still always cite your sources, always. Okay, so what's included in the public domain? Well, this right here is clear as mud. We've got all works published in the US before 1923, all works published without a copyright notice from 1923 to 63, but without copyright renewal, all works published without a copyright notice from, it gets complicated really quickly, right? And other. Luckily, there is this handy dandy public domain slider, and you can slide right here and it will give you an answer, which is pretty cool. And librarians made this up. I liked to show this one because it's published after 2002, but created before 1978, and the author is dead more than 70 years. So that's in, right. It gets, yeah, it's crazy. So it gets complicated, but this slider right here, and they've actually redone it. So this is a newer version of it, which is really cool. Now there is a thing, Creative Commons, and I know that most of you have seen Creative Commons, and this provides a range of licenses, and they're all different, right? So some folks will put something on the internet and they just want attribution. You can use it, just give me attribution. Or you can use it if you're not for profit, but you can use it ever how you want to, but you can't create derivative works from it. So when you do find something, just because you see the Creative Commons, that doesn't mean that there aren't limitations or requirements that you have to follow. These are not necessarily free from all copyright. It depends on what the person that created them or the item wants to assign it, right? So attribution, non-commercial, and you can get all the way down here to attribution, non-commercial, and no derivatives. So you want to make sure you look and that you're doing what they ask you to do. And this is one of the things, other than, just not taking other people's stuff and using it ever how you want, you can actually get into a good bit of trouble with this. You have to pay the dollar amount of damages and profits. The law provides a range for each work infringed. So if you took a whole bunch of images from somewhere, each work infringed, so you get up to I took 10 images and I didn't do my due diligence to make sure that I cleared copyright. So now we're up to $1 million. So you got to be careful. You have to pay all the attorney fees and court costs. You can get an injunction, you can impound the works, and you can go to jail. Nobody wants to go to jail. Now, in academia and education, we have fair use. And I love this quote. Fair use is both an extraordinary opportunity and a source of reoccurring frustration. And part of the reason we don't have definite answers is because when somebody does do or commits copyright infringement, it's usually from a misunderstanding and they didn't know. So the copyright holder contacts them and says, you messed up, take it down. And they do. So there's no lawsuit done. There's no case law to fall back on to say, yeah, this happened. So definitely don't do this, because they settle out of court. So that's why we still have so much gray area, other than it's a complicated issue, is there's no case law because they settle. Okay. So we've got fair use. So we're going to talk about using things in the classroom, scholarship, research, that sort of stuff. And we've got 4 main pieces to fair use. The first piece is the purpose or character of the use, right? The second is the nature of the copyrighted work. 3 is the amount and substantiality, that's hard to say, of the portion used. The effect upon the potential market. And all of these things, when you go to apply fair use, you want the checks to be in all 4 of these. Generally, 3, but I like for it to be all 4. So what does this look like? What do I mean? So the purpose. So I've got an image or an article I want a class to read. So I'm going to say, okay, the purpose is for class. So teaching, good. Scholarship, good. Nonprofit educational institution, great. And I'm going to restrict it to the students or other appropriate group. So I'm not going to just post it out there on the web for everybody to find and download, right? It's going to be restricted to the students in my class. And over here, you see the column for opposing fair use. So commercial, if I'm profiting from it, if I'm doing an entertainment, it's bad faith behavior, you know, just like those mirror sites where you can download things without going through the journal publisher, that sort of thing. And I don't give the credit to the original author. So all of these, you don't want to check anything over here. So the more checks you got over here, the better you are. So the same goes for the nature of the work, right? Is favoring fair use there? Is it published? Is it factual or nonfiction? Nonfiction tends to be harder to, we'll just say factual things are easier to handle via copyright rather than the nonfiction, right? And I got a question?
Rather than fiction.
Oh, rather than fiction, my bad. Important to favored educational objectives. And over here, you know, highly creative things, that's what I was trying to get to. Art, music, novels, that sort of stuff. And there's your fiction. And the amount of it, favoring fair use, small. The portion is used, it's not central or significant to the entire work. So that's called like the heart of the work right there. You know, the thing that makes it special. The amount is appropriate for favored educational purposes. All of these favoring fair use. And you want to do these checklists with each thing. And then the effect, right? And look at this one. User owns, lawfully acquire or purchase copy of the original work. So if you own a copy of a book and you want to put a chapter on e-reserves or have a chapter, just a chapter of that book for your class, you already have a lawfully acquired copy of the book, or the school does. So that's more favoring fair use. One or few copies made, and I'm just going to share it with, you know, my seminar class, not the whole freshman class, that sort of thing, or just a colleague that we're working on something together. And you're not hurting the market because it's one chapter. Folks aren't going to buy a book for one chapter generally. All right. There's no similar product marketed by the copyright holder. And there's lack of a licensing mechanism. So, you know, if the book is only in print and you just want one chapter, so the library can't buy an electronic version of the book for each student to go and get that chapter or whatnot. It's just in print. You just want them to have that one chapter because it really illustrates what you're trying to teach. Then that all favors fair use. So opposing fair use, right? You don't want to do anything that could replace the sale of the copyrighted work. There's licensing things available, you know, affordable permissions available. You make a bazillion copies of it and give it to all your friends and neighbors. And then, of course, you posted it on the web or other public forum. And so we had a student here that subscribed to Sketchy, I think it was Sketchy Micro, and she posted a bunch of their slides on the thing for her classmates. And we had to tell her that she could not do that. And she was very apologetic and took it right down. But, you know, you can't just license something for yourself and put it out there for other people. Now, libraries have exceptions, and this is pretty cool right here, especially for us librarian folks. It's not an infringement for a library archives or any of us librarian archivist types acting within the scope of our employment to reproduce no more than one copy of a phonorecord of work except as provided in subsections blah. Then we get into some stuff. So for those of you that know, libraries do interlibrary loan. And for you non-librarians, that's where if you need an article, we don't have it full text, we borrow that article or we get that article from a library that does have it full text. And 5 minutes, I'm almost done. So we have to attach this right here that you will use it, you applying fair use, right? And there's a library exception slider right here that's real cool. You also get people that want the entire work. So can I make a copy of this entire work? And this is interesting because you actually can. You actually can in these certain circumstances right here. And that's one of them is if it's not at a fair price somewhere else. But again, there's been no case law and fair price is not defined. So it gets sketchy there. And there's a slider for that too, or spinner, not a slider. So we got a slider and a spinner to help us with our copyright law. This is just a screenshot of the LibGuide, and I can send this out so folks can look at it. I tried to get all the good stuff on here. I think we're at the 2-minute warning. I just wanted to mention the TEACH Act. The TEACH Act really is for distance education, and it's really focusing on performance and display over the internet, right? And it's just trying to balance the needs of distance learners with copyright holders. So the TEACH Act is much more narrow than fair use and copyright and applies to distance learning. And there's some limitations. When you get into this, if you're teaching a full on distance education class, like you can't transmit the textbook, and you got things like reasonable and limited portions. And again, there have not been a lot of case law on this, so it's going to be interesting to see how that works with COVID. I think a lot of people probably broke some laws, but I don't think anybody's gonna come after us. Now, if we keep doing it, that might be different. All right, so we wrapped that up kind of quick because I overdid, like I tend to do. Those of you that know me know I tend to overdo sometimes. So I got questions. We've got a survey there to let us know how we did. And then we've got to save the date for the next workshop, which I'm really looking forward to. I mean, I just love the name of that, LibKey Nomad. That's cool. And so then you can register right here. Any questions? Comments? I did have a little extra caffeine today. Yeah, most libraries do have their own copyright guide.
That was great, Lisa. Thank you.
You're welcome. But if you're confused, you don't know what to do, please ask. We don't want anybody getting in trouble. We can definitely help point you in the right direction and help you get those copyright permissions and things like that. It's kind of what librarians do. So y'all just ask your librarian. Yeah, that slider and the spinner is nice.
I had a question about, I'm from CHSU, Dr. Yoshida here. I had a question about citing images because that comes up a lot for lectures and things like that.
Yeah, so you definitely want to cite your images. Most of the library resources, the licensed library resources will have ways for you to download images into your PowerPoints that cites it for you, which those are really handy. And I've actually included that in my LibGuide that works. If you get them from like just the general web, you want to really try to find out who made that image. But are you mainly talking about things from library resources or
Yes.
something else?
Yes, thanks.
Yeah, so I mean, you can cite, generally there'll be a little blurb under the image, but definitely you can go in there and make an account, and usually you can download, and here, let me show you right quick. Let's see. If we go to, and Nicole put the link in the chat there to it, but we've got on this one, images. So if you do like Access Medicine here, it's going to have the source and everything with you. I mean, there for you that you don't have to worry about. Here's a one from LWW, Clinical Key. It's got the citation right there, or the information right there. So most of these resources, especially library ones, they try to make it easy for you to do that. And your librarian should be able to help you do that, show you how to download those things. But you mainly just want to, when you're doing an image from a textbook, at least cite the textbook and the page it's on. Anything else? That was a whirlwind tour. Well, if I got you overwhelmed and you think a thing, reach out to your librarians, reach out to us here at ACOM. We're always willing to help our library colleagues and our health sciences folks. So just let us know. We're here for you.
Thank you, Lisa. This was great. Really enjoyed it.
Awesome. Thank you. It's hard to make copyright fun.
But you did a really good job.
Thank you.
One thing, though, I wanted to just mention, CHSU is a for-profit institution. So it sounds like we would never be eligible to for the TEACH Act. It couldn't apply to us. Is that true?
We would have to look into that further and make sure. But
yes, yes, that's true. This is Katie Hoskins. I'm one of the librarians at CHSU and work with Joanne. I don't talk about the TEACH Act because it does not apply to us as a for-profit school.
Gotcha.
And also, Lisa, from your experience, and I'm sorry I didn't introduce myself. I'm Joanne Muhlenbach. I'm the library director at California Health Sciences University. The other thing, it sounds like we would have to look at each and every license to find out what they allow as far as faculty who may want to take some of the licensed resources and put it into, say, a course pack or handout.
Yeah, course packs are tricky because generally you make a student buy a course pack, and see then you're kind of making money off of it. Handouts are better. Linking to the resource is best. We use e-reserves. Generally, your course shell at least is behind a password. Only the students in the class can get to it. But yeah, if you look at your library license, they're the ones that we get. We make sure that they at least say you can use whatever you want when you're teaching a class. You can, as wide open as you can while you're teaching a class. But it is different. So we have professors that they use the image in the class. Well, then they say this was, or a TBL, was team-based learning is even better. So I'm going to use this image. And then they want to write a poster about their TBL because it's a really unique TBL, and they want to use that image. But then when you go to a conference, you have to make sure that you've got the right permissions to use that image outside of the classroom. But we do look and try to make sure in our licenses that you can use it ever how you want in the classroom. That makes sense?
That does. That's helpful. Thank you.
Most of the vendors, they want you to use the stuff in the classroom. And most of them like for you to use stuff at conferences too, because especially they want attribution. So, that's free marketing for them. So generally when you ask, the answer is yes, especially when you give attribution.
And do you recommend that when we're creating our presentations, our slides, that the citation be on the same slide as the image, as opposed to putting just a list of where you found the content as a part of the bibliography?
Generally for that, I'm going to do what looks best, just so, you can easily match up the citation to the image. You put a little 1 or 2 or a name, just so you know which citation goes with which image. I think you'll be okay. And that's what I do personally, because I can't give legal advice. But yeah. But yeah, again, if you download it from, but a lot of times when you do download slides, they have done their marketing piece on that slide, so it doesn't look like your other slides. But if you're doing a poster or whatever, just making sure you cite it and you can match the reader or viewer can match up the image with the citation. You should be good. I've never gotten in trouble.
Thanks again.
And remember, one of the main keys is that you're not doing this for money. You're not getting paid to present at a conference. You would be getting royalties for a textbook, though. So, using the same images in those 3 venues, a classroom, a professional presentation, and a textbook, are very different. And money usually is one of the keys. Are you making money? Anybody else? Okay. Well, if y'all think of something later, don't hesitate. I pretty much always have some electronic device with me, so feel free to email me anytime.
Thanks again, Lisa.
Yes, ma'am.